people can. I may darken or lighten depending on how much smoke is going through the street. So for that, I apologize. It is a bit of an unusual situation here at the moment. So with that, maybe start out by just establishing a quick reminder about a few things about the video meetings that we're having because of the pandemic. For commissioners, if you wish to speak or ask a question, please use the raise hand feature and the chair or staff will ask you to unmute and speak. Okay. Also, I also need to make this statement that as a result of the state's public health efforts to reduce public gatherings, this meeting will not include live public participation. But just as a reminder, it's in our September meeting that we will have testimony from the public. And so again, that's usually the time where we get to hear most of the public testimony. And at the end of the meeting, there'll be another statement about how people who would like to send written comments, how they can do that. All right. So to begin, we also need to do, because of the video nature, we need to do a public roll call. And so I will read off the names of commissioners, both voting and non-voting. I'll start with the voting members first. When you hear your name, please say here. Ronald Buing.
Here.
Diane Dick.
Here.
Sharon Kyoko.
Here.
Andy Meadows.
Here.
Now, I'm the chair, Grant Forsyth, here. For the non-voting members, Representative Gary Paulette.
Here, Jerry Paulette.
Sorry, apologize, Jerry.
No problem.
And State Auditor Pat McCarthy. Okay. With that, I will welcome Representative Paulette. Apologize for the name. You are replacing Senator Mark Mullet as the new chair of the Joint Legislative Audit and Review Committee, JLARC. And I'd like to give you just a few minutes to introduce yourself if you'd like.
Thank you, Chair Forsyth. I first want to say a tremendous thank you to the members of the commission. You play a vital role in ensuring that the public has confidence that tax preferences are not undermining the equity and intent of our state's tax system. And you do a great public service, and I've attended meetings in the past, and we, as members of the Joint Legislative Audit and Review Committee, on which I've served for a good number of years, we really rely on and utilize your thorough review, your comments. You're the ones who are hearing the public and stakeholder testimony and reviewing it and giving us invaluable input to determine if we should add additional comments and how we, as a legislature, when we go back into session, should respond to the recommendations of the legislative auditor in terms of whether or not tax preferences are meeting their intent. Are they actually cost effective? Do they make sense? Do they inspire confidence in our tax system? So I really want to thank you for the great work you do and encourage people to join you at the September meeting and offer comments and engage in the discussion. So thank you all.
Thank you very much. And just a reminder to commissioners, Representative Paulette has really been an active member. He's paid a lot of attention over the years to what this commission does. And so we have a very experienced person now representing the legislature as chair. So thank you again, Representative.
Thank you. And I will say, unfortunately, due to a prior conflict, I'm only on for the first hour today, but I will be doing my best to make your meetings. Thank you.
Thank you. We do appreciate that. In the past, a representative, either representative or senator's presence has been very useful when certain issues come up with the tax preferences. So we'll look forward to that. Just a quick note, again, to participants is that we do have agency representatives that are on the call today, for example, from the Department of Revenue, that are available for our questions. And that's usually the case. And so for all those folks, I thank you for appearing today to be available. And so we look forward to maybe relying on your expertise as we go forward. So with that, we'll go ahead and move on to commission business. The first thing we need to just really announce, and I'm very grateful for this, are commissioner reappointments. And in particular, I'm very grateful that Ron Buing has been reappointed, and as well as Andy Meadows has been reappointed. I'm very grateful for both of you, your willingness to serve. I know that Andy, you're incredibly busy with your work with the school district, and Ron, you're incredibly busy being a new retired person, which, you know, only joking aside, does have certain responsibilities, especially to your spouse. So I am grateful that you're willing to do it again. So again, thanks so much. It's good to have that experience back on the committee. Okay, with that, we only have one action item, I think, according to the expanded agenda, and that's just the approval of the May 5th, 2021 meeting minutes. And so with that, is there any discussion anybody has about those minutes? Okay. Well, hearing none, do I have a motion to approve the minutes of the May 5th, 2021 meeting?
So moved.
Do I have a second?
Second.
Thank you, commissioners. So with that, I'm going to go ahead and just do a roll call vote. And so when I call your name, just say yay or yes if you approve, nay or no otherwise. So Ronald Buing,
Yay.
Diane Dick,
Yay.
Sharon Kyoko,
Yay.
Andy Meadows,
Yay.
myself, yay. So passed. Okay, with that, we're going to go ahead and move on to the virtual meeting format, which the legislative auditor will discuss.
And thank you, Mr. Chair and members of the commission, and our newly reappointed members continuing, and very excited to see Representative Paulette join your group today too. Just a quick, brief informational item, because this was kind of has still been up in the air and an ongoing item that we're making sure we're on top of, and that is that there continues to, because of the public health emergency, there continues to be a emergency proclamation from the governor that for all entities such as the Citizens Commission that have public meetings, that during the course of the proclamation still being in effect, we are required to do our meetings in a virtual format. So we are going to be continuing, and I think it's looking probably likely, that's unlikely it will probably change before we complete our business this year in October. So at this point, I just wanted to put all the commissioners on notice and announce to the public that the remaining 2 meetings after today, we anticipate are also going to be in a similar format. As Dr. Forsyth pointed out, Chair Forsyth noted, we are setting up a process, even though it's virtual, we're setting up a process for in-person remote testimony for the September meeting, since that's a major order of your business there. So we've had a lot of success, and the legislature in general has done a great job, I think, setting up the infrastructure to make that remote testimony possible. So we're very hopeful that's going to be continuing to be a successful process and allow the testimony to be as informative as it has been in prior years. So that will be what we will be undertaking as our main order of business in September. But then, of course, we anticipate the October meetings are also going to be in the same virtual format. And as Dr. Forsyth noted, we're also making sure that we're publishing the ability for folks to provide written comments on any of the meetings to all of you, and relative and consistent with our past practice, we're making all of that, any public testimony we get in writing, We're publishing to the website, so it's available for anybody and easy to get to. With that, I'd be happy to answer any questions if there are any from the commissioners.
Keenan, this is Grant. So in terms of staff there in Olympia, so are you all still working from home? I know that there was some ability to return to work. What's the current status of staff?
Yeah, we do have the ability to, the staff have the ability to access the legislative facilities if they need to do so for their work. For the most part, staff still are working predominantly at home, but when there are instances where it's better to be in the office, we do have the ability to get access to the facilities. They're not generally open to the public yet at this point. Then for items like what we're doing today for public meeting, that's the time where some of the staff do go into our own office just to make sure that their internet connection works appropriately when they're in a presenting role. So that's where we are right now.
Well, I can't speak for the other commissioners, but I do miss the in-person meetings. It's certainly a lot easier for me to run the meetings in person. But again, speaking for my employer, we're also, because of the Delta variant, we're now back in this situation where, it is harder for us to travel any place, company restrictions on that, safety restrictions and so forth. So it does appear that at least for this year, for sure, we're still going to have the video all the way through. So again, anything that staff can do to streamline this, especially for people who want to participate in the hearing process is great. So anything that can be done.
And of course, we have your Assistant Attorney General, Stacia Hollers, here as well, if there are any questions relative to open public meetings.
Yeah, and on that real quick, I'm assuming that there has been no other legislative adjustments to that, to what we're now experimenting with, that there's been no, in the last session, did the legislature change anything about these types of meetings and how open meetings are to be held under the pandemic?
I see our very astute attorney, Stacia, has turned her video on, and I'm sure she could address that the best.
Commissioner Forsyth, no, there have not. There were no changes from the legislature. The governor's proclamations, the governor's office is currently reviewing them all and making adjustments as time go on. This particular proclamation is still in effect, has not been rescinded. Some proclamations are being rescinded, and so I'm keeping an eye, and we'll certainly update the staff if there are any changes. But we're currently under the same proclamation.
Okay, good to know. The reason I asked was, of course, the legislature was essentially virtual, and I didn't know if there were any lessons learned that came out of that, any complaints that came out of that maybe the legislature had to pivot a bit. But that sounds like everything's kind of status quo.
Yes, of course, here's an opportunity, Chair Forsyth, where you can ask your legislative non-voting member if he has any comments on the legislative session or wants to offer any thoughts there.
Representative, did you have any comments to make about that process?
I'm sorry. Trying to figure out why the Zoom thing is up instead of the picture. The legislature held a incredibly active session all on Zoom and got a heck of a lot done. Nothing has been changed in terms of plans for open meetings. Ironically, I'm the prime sponsor of legislation worked on with cities and counties to allow for emergency meetings, hybrid or online, in the future, which did not make it through the Senate through the floor, so we'll be back next year. But for right now, we're all operating under the same rules that we were, and I think our experience has been, and I think you'll find that The ability of people and interest to comment is growing because of the ease of using Zoom. So you might want to consider taking, holding hybrid meetings when we return to public meetings. Excuse me, when we return, this is a public meeting, of course, when we return to in-person meetings, excuse me.
Yeah, I think we're entering what I would call, generally speaking, a hybrid world coming out of the pandemic. So we may all have to get used to that. Commissioners, any other comments about the meeting format? Oh. Okay, hearing none, we'll go ahead and move to the next section of the expanded agenda, which is the 2021 tax preference performance reviews, the preliminary report. And I believe Eric Thomas will introduce this section. Eric, can you?
Yeah, I think
Okay.
Dana is sharing her screen right now. Apologize for that.
Okay, okay. I was
Morning.
worried that your sound wasn't working, so I was just checking.
Good morning, Mr. Chair, members of the commission. My name is Eric Thomas, staff to JLARC. With me are my colleagues Scott Hancock, Josh Karras, Dana Lynn, Rachel Murata, Pete Van Morsel, and Eric Whitaker. And we are presenting JLARC's preliminary report of its 2021 tax preference performance reviews, in which the legislative auditor recommends action on 4 of the 7 preferences that were reviewed this year. This is the second step in the public hearings of these reviews. In July, we presented these reviews to the full JLARC committee, and we are before you here today to present those same reviews. In September, you'll reconvene to take public testimony in each of these preferences. In October, based on the staff reports and what you learn in public testimony, we'll adopt comments on the reports. And in December, we will present the proposed final reports to JLARC with your comments. As you'll recall, you directed JLARC staff to conduct fewer reviews in greater depth. And the reviews that you're hearing today were prioritized for review in May 2020. The considerations that you asked in prioritizing these include the specific legislative guidance, the likelihood of data to conduct an analysis, feedback from legislative staff, and whether or not there were stated outcomes for the preference. With this extra time, we were able to conduct extensive stakeholder outreach, site visits, perform advanced statistical analysis, and work with subject matter experts, all that you'll hear about in the forthcoming reviews. And briefly, the legislative auditor recommends action on 4 preferences, recommends allowing 1 to expire, and recommends that the legislature clarify the intent of another. And finally, there is 1 preference that we presented to the legislature in advance of the 2021 session that would provide them the ability to act, and we will update you on the actions that they took and how that has played out. As a reminder, all of our reports have a 1-page overview available online and also have 1 to 3 minute video summaries. With that, I will hand it off to my colleague, Dana Lynn.
And actually, and I apologize to break in, Dana, just real quick. Since we just went through that overview, it's also important for me to remind all the commissioners as we begin to review these preferences to publicly disclose if you have any connection with any of these preferences, which actually I need to do now. So this will be a good reminder to other commissioners. So in the interest of the public record, I need to disclose in the case of the manufacturer's deferral, I actually sit on an advisory committee to the Association of Washington Business, which my company asked me to sit on. They often are involved on tax issues relative to manufacturing. There's the reduced B&O tax rate for printing and publishing newspapers. My company serves several large paper producers, One in particular serves the newspaper industry. Okay. Medical cannabis tax preferences. My company serves a lot of energy to cannabis providers. They're big energy users if they're indoor growers. Right. And also, certainly the credit for renewable energy program payments. My company is involved in the solar sphere, like many energy companies. And we both work with residences for putting on solar, and we have our own solar projects as well, and other renewable projects. So I just want to discuss that in the interest of disclosure. Ron Viewing, I see your hand up. You're on mute, Ron.
Sorry about that. Yeah, I just, my general one that I always do, I've been consulting with taxpayers in virtually all areas of Washington, B&O tax, sales and use tax, and numerous other taxes. Perhaps the health benefit exchange, other than using it, I don't have any anything there, but all of the others, I have represented a client on the private side at one point in time or another. I do not have any current clients using any of these exemptions, but I have been involved in the past with clients that have taken advantage of these different preferences.
Thank you. Sharon Kyoko.
Thank you, Chairman. In the interest of disclosure, I do sit on the board of KUOW, which is the NPR station here in Seattle. It is a news organization, so since we're going to be reviewing newspapers, I thought that would be appropriate to disclose. It does not do any print media, but it is a news organization.
Any other disclosures from commissioners? Thank you for that, Commissioner Viewing and Commissioner Kyoko. Okay, with that, I apologize for breaking in there. Please continue, Dana.
Thank you, Mr. Chair. Dana Lynn, staff with the committee. The first tax preference we'll talk about today is a B&O tax exemption for the health benefit exchange. The exchange this particular preference was established in 2013, and it's set to expire July 1st, 2023. And the estimated beneficiary savings in the current biennium is $2.2 million. The legislative auditor concluded that the preference is reducing the exchange's administrative cost by $1 million per year, and that allows it to maximize its funding for operating a health insurance marketplace. He noted the legislature should extend the expiration date or make the preference permanent. As I noted, this is a full exemption from B&O tax for all of the income that's received by the health benefit exchange. The exchange was established in 2011, actually, to help implement the Affordable Care Act in Washington state. It provides, among other things, an online marketplace that allows individuals and families to enroll in either private health plans or Washington's Medicaid program, Apple Health. And it's structured as a public-private partnership, funded fully by appropriations made by the legislature. And without this tax preference, it would be subject to business and occupation tax on those appropriated funds. We found the preference is meeting its inferred objective, and that was that the preference allows the exchange to maximize its total state funding. This particular preference was enacted in the legislation in 2013 that established the governance and the funding for the exchange. So it does serve kind of a structural purpose in that capacity. And it reduces the exchange's administrative costs by $1 million a year, or about 2% of the total state funding for the exchange. We found that since the exchange began, the uninsured rates in Washington have been at least 3 percentage points below the US average uninsured rates. And since 2015, at least 1.6 million or more Washingtonians have used the exchange each year to enroll in either a qualified private health plan or in Washington's Medicaid program, Apple Health. The legislative auditor recommends the legislature extend the expiration date or make the preference permanent, and also that they add a performance statement that specifies the public policy objective. In addition, he recommends the Citizen Commission consider if this preference is critical to the tax structure, and if you determine it is, to exclude it from future reviews. Mr. Chair, I'll pause a bit at the end of each preference review, if you don't mind, just in case there are questions.
Yeah, any questions from commissioners? Just one. Yeah, I mean, I think that because this is essentially making us compliant ultimately with federal law, it does make some sense to really remove this as something that's critical to the tax structure. Just getting a sense from my fellow commissioners, is there any objections with that? Okay.
Could you repeat that again, please?
So what they're proposing here is that because this particular tax preference makes us compliant with federal law, it does make a lot of sense to me that it be removed from future reviews. But I just want to make sure that I get a chance to get feedback from all the other commissioners about that possibility and what you think about that.
Does that also mean that we make the preference permanent?
No, it's not necessarily permanent. It just means that for the future, this would not be part of the normal review cycle anymore. It would be taken off the normal review cycle.
Okay, thank you.
Yep. And this does come up periodically, and it's just I just happen to agree with this recommendation. I'll say this now because because it is making us compliant with essentially federal law. But it's just something to think about as we go forward and as we make our final decision and our final recommendations. Okay.
All right. We'll move on then. The next tax preference, I'll be joined by my colleague Pete Van Moorsel to tell you about a sales and use tax deferral program for certain manufacturers in the state. This was enacted in 2015 and is set to expire January 1st, 2026 for new participants. And we estimate the beneficiary savings in the upcoming biennium of between $240,000 and $380,000. The legislative auditor concluded that 4 businesses have used this deferral program and have met their job goals through temporary construction work rather than permanent manufacturing jobs. Businesses likely would have built the facilities without the deferral. And finally, to increase jobs or training, the legislature should consider modifying the deferral program. This program requires businesses to apply to the Department of Revenue, and if they are okayed to participate in the program, it allows them to defer sales and use tax on up to $10 million that they spend to either build, expand, or remodel manufacturing facilities or buy manufacturing machinery or equipment. Since 2018, the program has been open to 2 businesses annually, one of which has to be in Eastern Washington and one in Western Washington per statute. After the businesses have completed their construction and the facilities are deemed operationally complete by the Department of Revenue, businesses have a 5-year period where they make no repayments on the deferred sales tax. After the 5 years is up, they begin repaying over a 10-year period in equal installments of the tax only. No interest is charged unless there is a default or late payments. And finally, the last portion of this we would like to highlight is that the state portion of the sales tax that's repaid, the 6.5%, is earmarked to go into a special account to fund training for manufacturers and also apprenticeships for them. It's called the Invest in Washington account, and it's to be administered by the State Board for Community and Technical Colleges.
4 businesses have claimed this deferral and filed annual tax performance reports. And these include 2 businesses on the west side in Maltby and Frederickson, and 2 on the east side in Spokane and Walla Walla. These businesses manufacture products ranging from dump truck parts and concrete pavers to agricultural inputs and wine. And together they've deferred a total of $1.3 million in state sales and use tax. This is estimated by JLARC staff to represent 18% of the maximum amount of state sales tax that could have been deferred if all the available deferral slots had been claimed, and each of these deferrals had been for the maximum amount of $10 million in purchases. The legislature set a goal that each deferral project generate at least 20 full-time jobs and defined those jobs to include temporary construction jobs at the facilities, as well as permanent full-time jobs at the facility within 1 year of its completion. Excuse me, that first bullet should have been temporary construction jobs used to build the facilities. So all 4 businesses met the job goal through temporary construction work, and none reported creating 20 full-time manufacturing jobs at the facility. The change in full-time jobs in the first year after its completion ranged from a reported reduction of 7 jobs to an increase of 6 jobs. Further, JLARC staff used an economic modeling tool to estimate that the construction spending supported an additional 122 non-construction jobs. All 4 businesses report that they likely would have built these facilities even without the deferral, but they did add that the deferral enabled them to build earlier, to complete more construction, to plan for future growth, and to spread over several years the tax liability that would otherwise have been due after construction.
Finally, we found there are no impacts yet to job training programs for manufacturers in the state. We estimate the first repayments from taxpayers will begin or are due by the end of this year. And we estimate that repayments will peak at $325,000 in 2031. That's based on current participation and an estimated future participation based on past businesses that have used the program. We contacted the State Board for Community and Technical Colleges to ask what they plan to do with this anticipated funding. They noted they're developing plans right now to provide manufacturing, occupation training, and apprenticeship programs with funding. The legislative auditor recommends that the legislature extend the expiration date and modify the program. Extend the date because each business has met the stated legislative goal of creating 20 full-time jobs, and repayment of the deferred taxes is expected to help fund future training. However, if the legislature wants to encourage businesses to create and retain more manufacturing jobs, it could modify the preference by focusing on creating more full-time manufacturing jobs rather than temporary construction work, or directly appropriating money to the State Board for Community and Technical Colleges to provide manufacturing training and apprenticeship programs.
I do, just real quick on that, one comment I would have is that I remember a few years ago, we reviewed data centers. And as I recall, data centers, a big part of their job creation was actually the construction jobs to build the data center. And this sounds like maybe we have a similar kind of economic impact here. It's just a general comment that for a lot of these preferences aimed at job creation, it seems that the job creation tends to be centered a lot in the construction center. And I noticed that Commissioner Meadows, you have your hand up.
Yes, I was just wondering if there was any sense if the pandemic may have impacted the company's ability to create manufacturing jobs, or was the data collected before the pandemic was in full swing?
I guess I'll jump in on this. The data is prior to the pandemic. We got survey data through 2019, so it was prior to.
Thank you.
And if I could, to Commissioner Forsyth's point about the job creation goals, that the data center preference also had a specific definition of the jobs for which a goal was set. And that definition specifically did not include construction employment for the data centers, whereas it is specifically included in this preference. And so that is a difference in how those two categories of jobs are defined.
Okay. Thank you. Questions from anybody else? Commissioner Kyoko?
Just to clarify, the 122 additional non-construction jobs, are those temporary or permanent?
That's a good question. And those jobs would be temporary. They are the indirect and induced jobs that would be created due to the temporary construction jobs that would be in each respective area of construction at that time. So they would be modeled to go away when the construction ends.
Yeah, just so let me piggyback on that question. So we have 20, has met the legislative goal of creating 20 full-time jobs. Is that direct, or does that include the indirect?
Mr. Chair, that includes just the direct jobs, and that is solely the sum of the full-time manufacturing jobs and the part-time construction jobs only. It doesn't include that 122 number, which was provided for additional context.
Okay, I just wanted to, that's what I thought. I just wanted to make sure. Okay. And just real quick, so if I understood also the money flowing to the community colleges, they have not yet designed a program for that money. Is that correct?
Mr. Chair, we contacted them. At the time we contacted them early last year, they were working on strategies to use the money. There are currently apprenticeship programs, some apprenticeship programs established. They were looking at trying to create more of those and also to utilize the funds in current and potentially new training programs directed to the manufacturing industry.
So the money flowing to them, is it restricted to manufacturing training programs under the current preference?
Legislatively, yes, they are to use it for manufacturing industries.
Okay.
And manufacturing and occupation, manufacturing and something occupations, yeah, but basically manufacturing.
Okay. Production and manufacturing related.
There you go.
The pandemic hasn't completely destroyed me, but it's coming close. Okay. Any other questions about that? All right. Thank you. You can forge ahead.
Good morning, Chair Forsyth and other members of the Commission. My name is Eric Whitaker, staff to JLARC and the Commission. The next review we'll discuss is a preferential D&O tax rate for businesses that print and publish newspapers. And the legislative auditor concluded that the preference is providing tax relief for newspapers, but the industry continues to lose revenue and jobs as it seeks to stabilize financially. The preference is currently scheduled to expire July 1, 2024, and we estimate the beneficiary savings for the present biennium are $823,000. In 2008, the legislature updated the statutory definition of newspapers to include electronic versions of qualifying print publications. Prior to that change, print ad revenue was subject to a lower B&O rate than digital ad revenue. And for a newspaper producing both a print and a digital version, this meant that ad revenue had to be separated out and different tax rates applied. And as stakeholders testified at the time, ad buys often bundle print and digital, and that makes it difficult to differentiate revenue streams and apply different tax rates. After the definitional change, digital-only newspapers continue to be taxed at a higher B&O tax rate. The following year, in 2009, the legislature created this preference, reducing the B&O tax rate paid by newspaper printers and publishers. And this was in response to multiple years of declining revenue across the whole industry and the closure of some newspapers in Washington. And the chart along the bottom of the slide shows the two B&O rates that have been paid by newspapers over the last 12 years. And this is based on their categorization as either a print publication or digital-only newspaper producer. The legislature last modified the preference in 2015 when it extended the expiration date and added a performance statement. And in doing so, it identified two public policy objectives. First, to provide tax relief to the newspaper industry while it adjusts to revenue losses and technological change. And two, to provide a permanent uniform tax rate for revenue derived from different sources. The legislature also directed JLARC staff to evaluate the year-to-year change in gross revenues for the newspaper businesses claiming the preference. And if the 3 most recent years show growth, the intent is to let the preference expire. In our review, we found that 164 unique beneficiaries claimed the preferential rate since its extension in 2015. Since then, the aggregate value of the preference has decreased, and the number of businesses claiming the preferential rate has declined in 4 of the last 5 years. Newspaper printers and publishers account for 2/3 of all beneficiaries, with non-newspaper beneficiaries including some chain supermarkets, advertising agencies, and commercial printers. And this results, this results from a statutory definition which focuses on form and frequency rather than content. So for example, focusing on frequency of publication and the materials used rather than content minimizes the risk of running afoul of US Supreme Court decisions that bar different tax treatment based on content. We used Department of Revenue tax return detail to assess annual gross revenues and found that among newspapers claiming the preference, revenue fell by $136 million, or about 29% between 2015 and 2020. And this represents an average annual loss of about $27 million. We also used employment security records, employment security department data records to look at newspaper employment between 2015 and 2019. And over this period, employment at beneficiary newspapers also fell by 1,126, or about 38%. Despite the revenue losses and downsizing, newspapers in Washington are pursuing non-traditional funding sources. The Seattle Times, for example, has partnered with local entities such as the Seattle Foundation to help fund its news gathering operations. The Spokesman Review is one of a few local papers working to secure funding to create endowment-funded reporting positions. And McClatchy-owned newspapers in Washington have partnered with Report for America to add reporting positions focusing on specific communities. And all 4 of the newspapers recently launched funding drives to raise tax-deductible donations to help finance those positions. At this point, it's too early to tell whether these and other funding approaches mentioned in our report will be successful long-term or will be adopted more widely. If the legislature wants to consider assistance beyond tax policy, other jurisdictions may serve as a model for Washington. For example, a couple of states are exploring ways to assist the news industry, not just newspaper printers and publishers. So both New Jersey and Colorado use grant funding rather than tax preferences, so that media organizations can do such things as train journalists, foster collaboration across newsrooms, and enhance community engagement and civic participation. Various efforts have also been introduced in Congress in recent years. And for example, one bill proposed giving newspapers the same tax status as nonprofits, and another sought to create a panel to identify mechanisms for public funding. To date, such bills have not been passed, but considering the efforts in New Jersey and Colorado, and also federal efforts, as well as the industry's continued transition to digital products, a tax preference based on the production of a physical newspaper may be of diminishing utility for the industry. The legislative auditor recommends that the legislature should review this preference to determine if it provides sufficient relief to the newspaper industry and whether additional assistance is needed as businesses attempt to stabilize financially. The preference has been in place for 12 years, and the industry continues to lose revenue and jobs. And if the legislature is interested in helping the news industry more broadly, it should consider additional approaches.
Questions from commissioners? Okay, I actually have just maybe a couple of questions or comments. One is, most newspapers, I guess I want to understand how this preference is applied. Most papers are kind of a hybrid. They have an online component, a digital component, and a printed component. So for those papers, how do they, when they apply for this preference, is it being applied to their printed component only? I'm assuming.
No, in order to claim the preference, you have to produce a physical newspaper. And so it applies to both. So long as the newspaper produces digital content that shares content with the print newspaper, the preferential rate can apply to both, ad revenues from both. So it's only a business that produces a digital only newspaper pays that higher B&O tax rate, whereas the preferential rate is afforded to businesses that produce a physical newspaper and digital content that shares the title of the newspaper and also shares content from the print
So,
source.
so to clarify, if you're digital only, you have no print publication, you always pay at that higher rate.
Correct.
Okay. I mean, this reminds me a little bit what I'm seeing here. A few years ago, we reviewed preferences for the aluminum industry, and this was pre-pandemic, of course, and they came and testified. And one of the things I asked them is they were facing many pressures at that time. And I pointed out that, you know, relative to the pressures they were facing, market pressures globally, environmental pressures and so forth, that the tax preference they were receiving seemed pretty small. And I was questioning how important it really was. And they indicated it was very important and that they really needed this preference. And somewhat interestingly, about 2 months later, those companies shut down virtually all their smelters in Washington State. And so this is an interesting case. Again, I think maybe like the aluminum industry, where the preference is small compared to the pressures they're facing. And you do think maybe it's probably after 12 years, probably time to review that.
We did hear from some industry folks that basically echoed those concerns in terms of the amount of loss that the industry is taking on versus the value of the preference. While the businesses appreciate the assistance, it's not enough to offset the losses that they're experiencing.
Well, and I would also point out, it's sort of interesting is that you still see newspapers, even though they're moving more and more towards digital. I mean, and I think for a lot of newspapers, at some point, you just ask the question, do we go all digital, even if it means paying that higher rate? Because, you know, the pressures to do that just overwhelm maybe that little bit higher tax rate that you're going to pay on the digital only. So, yeah, I mean, there's some interesting things going on here that I think probably the legislature should take a look at. Any other comments about that? Okay, thank you.
Good morning, Commissioners. I'm Scott Hancock, staff to the committee. I'm here to present our review of 7 medical cannabis tax preferences. The preferences were created in 2015, and they have no expiration date. The estimated beneficiary savings for the 2021-2023 biennium are $4.9 million. The legislative auditor's conclusion is that the preferences provide tax relief to patients and cooperatives. After 2019 statutory changes, it is unclear how pending taxpayer guidance may affect beneficiary savings. Again, there are 7 preferences for medical cannabis. The preferences differ by which products, retailers, and customers are eligible. There are 6 sales and use tax preferences and 1 B&O tax preference. And I wanted to take a bit of time to point out that 3 of the preferences are for cooperatives and their members. While there are no exchanges of goods or services for currency within a cooperative, some activities are technically taxable without these preferences because of the transfer of ownership of resources. The preferences for cooperatives exist to ensure that the appropriate activities within cooperatives are not taxed. Otherwise, they would be subject to the use tax. The stated objective of these preferences is to reduce tax burdens on medical cannabis patients. Medically endorsed retailers are required in some way for 6 of the 7 preferences. Retailers with this endorsement register patients and designated providers into the patient database. They issue recognition cards, and they also make exempt sales. The map displayed on the screen now shows that medically endorsed retailers are available in 32 of 39 counties. And in fiscal year 2020, Washington had 510 licensed retailers, of which 275 had medical endorsements. And of those 275, 205 of them made exempt sales. recognition cards were issued by 188 medically endorsed retailers in 29 counties in fiscal year 2020. The availability of these retailers may limit use of the preferences. A statutory change in 2019 may affect future beneficiary savings. In fiscal year 2020, more than 87% of beneficiary savings were realized under one of the 7 preferences. This preference was modified in 2019 in Engrossed Substitute Senate Bill 5298. The modification made the preference refer specifically to DOH compliant products. However, there is yet to be any change to administrative code or to guidance to taxpayers. The Department of Revenue and the Department of Health have told us that they are working on updates to administrative code and to the taxpayer guidance. But because this work is not yet complete, the effects of those revisions are uncertain. We note in the report that in fiscal year 2020, less than 1% of beneficiary savings for this preference were from purchases identified as DOH compliant products. And the beneficiary savings from those purchases were approximately $7,000. The legislative auditor recommends that the preferences are continued because they achieve the objective of providing tax relief to medical cannabis patients. The Department of Revenue and the Department of Health should update guidance to reflect the 2019 statutory changes. And I'll pause to answer any of the questions you may have.
Questions from commissioners? I actually have a few, but I want, Ron, you have your, Ron Buing, please.
Yeah, I was just curious as to what the difference was, the Department of Health compliant products. What's the distinction between the products that qualified before and now qualify? Is it merely a matter of registration or something along that line, or is it the nature of the products itself?
Prior to the statutory change in 2019, the language of the statute for this particular preference referred to products that were beneficial for medical use was the term used. And that term was not defined in statute. So it fell to the Department of Health to determine what that meant. And so the Department of Health had to consider how they would go about identifying which products were beneficial for medical use and which ones were not. And ultimately, they had a rulemaking where part of the administrative code explained in the findings section that due to the Schedule I status of marijuana at the federal level, there was insufficient evidence to identify which particular characteristics of a marijuana product made it beneficial for medical use. So they further explained in that findings section that in the absence of evidence to do that, they would defer to the relationship between patients and their healthcare providers. And they would presume that any purchases of cannabis products by patients who have a recognition card, which means that they are registered in the patient database, they would presume that any marijuana products purchased by those people or their designated providers were being used for medical use. So the effect of that was that as long as you had a recognition card, no matter which marijuana product you purchased, it was eligible for the tax preference. When the statute was changed to eliminate the phrase beneficial for medical use and to use the phrase to refer specifically to compliant products, that changed the language in the statute to refer to products that met a product quality assurance standard that the Department of Health had established. So these are products that are subject to an extra level of testing. They're tested for heavy metals, for example. So by shifting the language away from products beneficial for medical use to compliant products, it would appear that the statute narrowed the scope of the of the preference to just products that had passed this DOH compliant product standard. However, there has yet to be any change to the guidance to the public or any change in administrative code to reflect the change in statute. And currently, the Department of Revenue and the Department of Health are considering whether there is an update that is needed. And if there is an update that is needed, they'll begin working on updating the WAC and or the guidance to the taxpayers.
So it sounds like from what I'm hearing is that it isn't so much the nature of the uses of the product or anything along that line that is that they're looking at this change. It's more along the lines of is that the prior products were not necessarily tested at the higher level to provide assurances that they meet the DOH standards for the product. Is that correct?
Yes, if I'm understanding correctly, yes. Prior to the statutory change, there was, because of the DOH interpretation of the statute, the department did not limit any products under the preference. The only requirement was that you were a registered patient in the patient database and that you had a recognition card that reflected the fact that you were registered in the database.
Yes, and now it appears that there would have to be some sort of an effort by the producers to certify essentially that the product was compliant with met this higher testing standards established by the DOH.
I think that is to be determined based on the Department of Health and the Department of Revenue review.
Okay, so it's not necessarily determined that those additional standards would have to be met at this point in time. They're still debating what needs to be done there, is what you're saying.
They're still considering whether the change in statute requires a change to the administrative code or the taxpayer guidance, correct?
Perfect. Thank you very much.
You're welcome.
Any other questions from commissioners? I just have a couple. Could you, for my benefit, you talked about cooperatives in the cannabis business. Are these grower cooperatives? Is that what you're referring to?
Cooperatives are limited to 4 individuals. There can be no exchanges of money within the cooperatives. The individuals that are participating in the cooperative must either be a patient themselves that is registered in the database, or in the case that a patient is too sick to practically contribute their labor or their resources towards the cooperative, a designated provider can act on their behalf. That designated provider will also be registered in the patient database and will also have a recognition card themselves. Cooperatives have to be located at the home of one of the cooperative members, and that address is registered with the Department of Health.
So we're really discussing here small scale.
Yes, there are additionally limits to the number of plants that each individual can have growing within the cooperative. So there's a practical ceiling to how large a cooperative can be due to the limitation on the number of plants and the limitation on the number of members.
Okay. So I have another question regarding, so this notion of medical benefits, if I understand this correctly, this is a hard, we can't really establish that because of the federal continued federal restrictions on marijuana. Is that correct?
That was the Department of Health's findings in which are stated in the administrative code in chapter 246-70010, I believe. They explain their reasoning there that the Schedule I status functioned as a limit to the amount of research that could be done that could help them determine particular characteristics of a marijuana or cannabis product that would therefore make it reasonably, that you could reasonably identify something by one of these characteristics as making the product beneficial for medical use.
I just think that's sort of interesting, given the fact that there's hardly a state in the union that hasn't had at this point some form of legalization, and that the feds are still wavering somehow as if we're all going to go back. I mean, it's just my personal comment that it seems to be a lot of value in actually establishing medical benefits at some point, but it sounds like that can't happen until the feds more or less catch up with the states, I guess. So we get these alternative definitions to judge by.
I think that was the position that the Department of Health found themselves in, yes.
Okay, thank you. Any other questions? All right, please continue.
Thank you. This next preference review is a property tax exemption for nonprofit outpatient dialysis facilities. The preference has no scheduled expiration date and an estimated beneficiary savings of $4.2 million in the 2021-2023 biennium. The legislative auditor's conclusion is that the preference provides tax relief to nonprofit outpatient dialysis facilities, which outperform for-profit counterparts on two standard measures. The legislature should clarify the intent of the preference. Again, the preference is a property tax exemption for nonprofit outpatient dialysis facilities. The exempted property is both real and personal property used exclusively by nonprofits for outpatient dialysis treatment. And beneficiaries of this preference must recertify their exemption each year with the Department of Revenue. We found that there are 27 facilities in 7 counties that are benefiting from the preference. And as you can see, all 7 counties are in Western Washington. The intent of the preference is unclear. There was no explicit policy objective in statute. So to infer an objective, we looked at the legislative history. Testimony during consideration of the bill that created this preference made comparisons to the property tax exemption for nonprofit hospitals for the support of charity care. However, unlike nonprofit hospitals, nonprofit outpatient dialysis facilities are not required to provide charity care. And additionally, over 99% of the treatments at outpatient dialysis facilities are for patients with end-stage renal disease. Medicare and the state's kidney disease program provide coverage for people diagnosed with end-stage renal disease. So with these programs in place, we concluded that support for charity care was not a relevant objective. We compared beneficiaries to their for-profit counterparts on several standard measures of dialysis facilities, and we found that beneficiaries outperformed on 2 measures. First, beneficiaries of the preference had a greater share of patients on the transplant waitlist, 16.3% versus 12.2%. And second, beneficiaries collected less revenue per treatment, $397 per treatment versus $480 per treatment. And on all other standard measures, beneficiaries and their for-profit counterparts performed similarly. This brings me to the legislative auditor's recommendation, which is that the legislature should clarify the objectives of the preference by including a performance statement. And again, I'll pause to answer any questions you may have.
Any questions? Oh, Commissioner Kyoko.
I just have a clarifying question. Would you say the counterfactual in this instance would be higher charges for the patients that would not be reimbursed by Medicare or by the other program?
This is a rather unique condition, particularly with the Medicare program. There's only one condition for which Medicare will provide coverage to eligible persons, no matter what their age is, and that is for end-stage renal disease. These both dialysis facilities, whether they're for-profit or nonprofit, overwhelmingly, over 99% of the treatments that they provide are for patients with end-stage renal disease. So between Medicare, this unusually large number of persons that are served by Medicare for this particular condition, and the state's kidney disease program, there's, relative to nonprofit hospitals, there's relatively little need for charity care. There's also patients of these facilities that have private insurance that cover them for these treatments as well. Did that adequately address your question, Commissioner Chioco?
I guess I was looking for something more definitive, in the sense that these costs would have to be borne by the individual, but I guess what you're saying is that most of them are covered one way or another by insurance or a program. So the burden will never fall on them individually.
Yes, between private insurers, Medicare, and the state's kidney disease program, virtually all treatments are covered by a third party.
Okay.
Commissioner Buie?
So, kind of continuing on what Dr. Chioco was inquiring about there, brought up a very interesting point to me, which was this idea of, if we, eliminated, this preference, would, these entities simply get more money, essentially from these other programs to cover the costs of doing this, or would it, it fall, on these nonprofits, which may, inhibit their ability to continue to offer these types of services. I do know that, having worked with other medical care providers, that let's just say that Medicare is often not the most generous of reimbursements. It does not provide the most generous reimbursements, and so oftentimes the way of keeping the cost down at the federal level is to reduce the amount of reimbursements that are available. Oftentimes you're limited on your reimbursements, and therefore, in that case, it would seem to me that if they're already, say, getting the maximum amount, so to speak, that they could get, that this would, that this would represent an actual cost to the nonprofits that they would not be able to obtain additional reimbursement for, thereby, somewhat in reducing their ability to provide treatment. Is that would that be the case, or do you have any input on that aspect?
I don't believe that the reimbursements by any third party is conditional on whether the facility is receiving a property tax exemption. I think perhaps I'm misunderstanding your question. I also don't believe it's conditional on the for-profit or nonprofit status of the provider.
So essentially then, they're receiving reimbursement for the treatments now, and that reimbursement is, I'm assuming, set with a schedule. So they would be, the nonprofit facility would be receiving, every time someone gets a treatment, they would get a certain amount of money. That amount of money would not increase or decrease whether or not this preference is available. So consequently, the elimination of this preference would result in an additional cost to those facilities that would not otherwise be reimbursed.
I think I follow you now. Yes, in the absence of this preference, the beneficiaries would pay higher property taxes than they currently are. That higher expense would not be reflected in the reimbursements from Medicare.
Or that cost could be pushed to patients. That was my point, is if the nonprofit doesn't carry that burden, then the burden would be carried by the patients by additional copays in excess of what their reimbursement would be.
Yeah, I think that's yeah, kind of an interesting point, actually. I think that's a good point.
And I might, if I can, Mr. Chair, offer another observation on this too, in addition to Scott, is another thing probably to reflect on is another possible counterfactual is looking into the fact that there is a robust for-profit dialysis treatment industry that provides, and correct me if I'm incorrect, Scott, but I think they provide a larger number of treatments than the for-profits. They do pay property taxes, and so they do have, in that context, they're providing similar treatments, and they do have a property tax liability. And I don't think we have, obviously they're existing still as businesses and have not folded. It's not, that treatment is only being provided by a nonprofit.
Correct. I don't have the figures immediately readily available, but Washington does have more nonprofit outpatient dialysis facilities as a share of the dialysis facility providers in the state. Washington has more nonprofit activity, but most states, and certainly nationwide, most of these dialysis services are being provided by for-profit companies, which are subject to property taxes.
Commissioner Buie?
Yeah, just one other thing. I was just, and this has to do with the actual recommendation. So we recommend clarifying the objectives. Was there any consideration of recommendation for continuation? It seems that there's that there is a benefit to the nonprofits that are running these clinics that that do obviously provide a significant source, especially for end-stage renal patients. And so I know that we have the clarification, including a performance statement, but was there evidence supporting the continuation of the preference in order to support these activities of the nonprofits?
Keenan, I think this is best addressed by you, but I think the recommendation you arrived at is in the absence of a clear intent of the preference. You deferred or chose to not make a recommendation along whether or not to continue or not continue the preference.
But I don't. But to jump in here, Commissioner Buing, I don't think we're ruling out that could be how the legislature proceeds. We're just the lack of clarity on what the legislature really wants to achieve, since it doesn't seem to be related to charity care. For instance, they could say it's those benefits like those two standard measures where they are performing better that they think is the value for providing tax relief to these entities, and that could be the rationale. And if that became the rationale, they are performing better on a couple of those measures. So, but that's where we kind of leave it to the legislature about, depending on what they want to say the objectives are. Then in a future evaluation by us, then we'd be able to weigh in more specifically with a continue or not continue kind of statement.
Thank you.
Any other questions? Okay, just on a side, I just want to get a confirmation whether or not the commissioners need any breaks, or should we just go ahead and forge ahead? Okay, I would say it looks like we can forge ahead. So please continue, staff.
Good morning, Chair Forsyth, members of the commission. Again, I'm Rachel Murata, I'm staff to JLARC, and I'll be joined by Josh Karras and Eric Whitaker to talk to you about a public utility tax credit for payments made through renewable energy programs. The legislative auditor concluded that this tax credit program increased Washington's solar capacity and met its solar-related employment target. It did not broaden low-income participation, and solar installations have continued after the program reached its funding limit. The credit is scheduled to expire in 2030, but as we'll discuss, it's not currently open to new participants. And we estimate beneficiaries will save $27.4 million in this biennium. Under the Renewable Energy System Incentive Program, or RECIP, customers of a participating utility can install renewable energy systems like solar panels or wind turbines and start generating electricity. The utilities pay their customers a set amount based on the electricity generated times a rate that's set in statute. And then the state reimburses the utilities with a tax credit for the amount they've paid. There are caps on the incentive for individual systems and individual utilities, and an overall $100 million cap for the program, which we'll discuss more in a minute. So in 2017, when the legislature last modified the credit, they noted two specific solar metrics for JLARC to measure the effectiveness of it. So we were directed to measure whether 115 megawatts of solar capacity were installed, and also whether there was an increase in solar-related employment. And that could be either in the number of jobs or in the state's ranking for jobs or jobs per capita. The legislature also noted they intended to broaden, to use community solar to broaden participation in the program by low income and other folks who may not own property that solar panels could be installed on. Community solar is a model that allows individuals to group together to fund a solar project and then share the financial benefit. So as I mentioned, there was a $100 million cap on the program overall. The program was scheduled to allow new participants until June of this year, but in February 2019, the Washington State University Energy Extension Program, which administers it, announced that that $100 million had all been allocated to existing projects, and future projects would all be placed on a wait list. So during the time the program was open to new participants, they installed about 100 megawatts of capacity, which is 87% of that target set by the legislature, excuse me. We identified a few possible reasons for that. The program includes about 7,500 solar energy systems, and 202 of those, plus 3 anaerobic digesters, were all installed before the program began. So those systems are allowed to receive the incentive, but don't count towards that capacity target. We also noted that the rates for the incentive ranged anywhere from 5 cents to 21 cents per kilowatt hour customer generates. And the rates are higher for systems that were installed the first year, systems that include components made in Washington, and systems under 12 kilowatts. So if the legislature was expecting fewer of those types of systems to be installed, that would have resulted in lower program costs and more participation. During the time the program was open to new participants, the state did meet those employment targets. We added about 1,500 solar-related jobs, and the state's ranking remained 21st in the nation when the program was closed to new participants. And Josh will talk to you more.
Morning, Josh Karras, staff to the committee. We use spatial analysis to identify areas where eligible participants were more likely to install solar systems. Counties east of the Cascades have roughly 21% of the state's homeowners, but 26% of the systems installed with the preference. We also found that systems east of the Cascades were 12% larger than systems west, and that on average, the panels produce 16% more energy. We also compared systems built through the program in urban and rural areas. Rural areas of Washington have 12% of the state's homeowners and 15% of the systems installed with the preference. Systems installed in rural areas were 15% larger than systems installed in urban areas. We used an adoption model developed by the National Renewable Energy Laboratory to estimate the impact of the credit may have had on solar installations. These models simulate how the solar market responds to various policy variables like the incentive rates and electricity prices, while taking into account residents' building characteristics and willingness to adopt the technology. By comparing the results of the model with and without the credit, we found that participants may have installed solar earlier than they would have without the preference. The model results only showed a 12% temporary increase in solar installations while the credit was in place. After 10 years, roughly the same number of systems were installed with and without the preference. We also found that systems were 32% larger while the incentive was in place. Because incentives pay the same rate for systems up to 12 kilowatts, it encourages owners to buy a larger system.
The program did not meet the legislature's intent of broadening low-income participation, so we used solar data from the Department of Commerce to review the income of homeowners borrowing money to install solar energy systems. And the borrowers earned an average of 180% of the county median in their areas, and the average income increased by about $22,000 between 2015 and 2020. Community solar projects were intended to help broaden access for those who don't own property for systems to be installed on, but these projects make up less than 2% of the installed capacity through the RECIP program. The benefits of community solar are different than the benefits of owning your own solar energy system. So specifically, the financial benefit for participants ends when the project term ends, and currently community solar project terms range between 8 and 25 years. We use data from 15 utilities across Washington on participants in a separate renewable energy program, which did not end when RECIP reached its funding limit. And among these utilities, installations of solar energy systems has continued after the initial decline when the limit was reached in early 2019. And December 2020 was the fourth highest month for new installations since 2015. According to the Solar Foundation's annual solar job census, solar-related employment declined in Washington in 2020 by 216 jobs, or about 6%. However, the state's ranking for jobs and for jobs per capita both improved, and this suggests that our decline was less than in other states. A solar panel manufacturer in Bellingham that testified for RECIP in 2017 reported that it needed the Made in Washington bonus to remain competitive as it sought to expand its markets outside Washington. And that company reports that it expanded manufacturing to a second facility and has grown from 70 to 240 employees. And also Washington is no longer the primary market for its products. The legislative auditor recommends that the legislature should allow this credit to expire in 2030 because the objectives are mostly met and installations have continued after the program funding limit was reached. And if the legislature wants to broaden low-income participation in the production and use of solar energy, it should consider other options.
I actually just have a couple of comments since this is in my area of work. Go ahead, Commissioner Meadows, go right ahead if you'd like to go first.
Hi, I was just wondering if there were any federal tax credits or programs working in tandem with this that may also be trying to accomplish the same thing.
There is the federal income tax credit, which I can't remember the percent this year, but it's declined in recent years, but it's still been available throughout the same period as this incentive program. So that would be a tax credit based on the amount paid for the system as a whole. So it's more of an upfront incentive. And at the state level, we also have net metering policies, which are sort of separate and in addition to this, and a sales tax exemption.
Just a couple comments about the low income participation. It was perhaps touched on just barely, and just to clarify, what we've discovered in our service territory is that low income people struggle to participate in these programs because of a couple big hurdles. One is they don't own their property, right? So the decision is not theirs; it would be a landlord. And furthermore, a lot of low income people live in multifamily, which also sometimes can be a little bit harder to retrofit with solar, depending on its age and so forth. And so I'm not surprised based on that alone that they've had limited low income participation. Of course, the other obvious thing is that even if you have a low income individual that owns their home, quite often they just simply lack the extra cash or resources to start the process to begin with. And so I think if you're going to redesign this for low income participation, you have to start out by recognizing the lack of ownership, the lack of income. And even in the case of community solar programs, you know, a lot of times low income people, they're living so close to the edge, they don't actually have the access to buy into those programs themselves without some kind of large subsidy, I would suspect. And I'd also say that the difference between urban and rural in terms of adoption and size doesn't really surprise me. I mean, I think in a lot of rural areas, I think you probably have a lot more ability to position them to get more benefit out of the sun. So you're going to justify a larger system. So those numbers don't really surprise me that you see kind of a difference between urban and rural households in terms of the solar size and frequency of use. Any other comments from commissioners? Okay, seeing none, we can move to the next.
All right, we have reached our last review for this morning. This is going to be a little bit of a review or a recap for you. We'll be telling you about some updates and some changes to a preliminary report that we presented to the legislature in January and to you at your May meeting. It's for a local property tax exemption for targeted urban areas. The tax preference now is scheduled to expire December 31st, 2030, and the estimated beneficiary savings in the prior biennium was nothing. And the legislative auditor has updated his conclusion to note that the legislature acted on his recommendation to ensure that the preference is available for future use by modifying the preference's population criteria and by extending the expiration date. Just a very brief recap about this to jog your memory. This is a 10-year local property tax, so it doesn't impact the state property tax program for manufacturing businesses. It was at that time. It was limited in statute to only be available in certain areas that had that met certain population criteria and also geographic criteria. And those statutory limits basically allowed it in only 3 cities in Snohomish County: Lake Stevens, Arlington, and Marysville. What we found when we dug into this last year was it was unclear if those cities could offer the preference any longer. And that was because in 2018, Snohomish County exceeded the population limits that were noted in statute. It was in a county between 700,000 and 800,000. They jumped over that 800,000 population limit in 2018. No businesses had applied previously when Snohomish County was within the statutory population limit. And so we also found that there are no other counties in the state that met that $700,000 to $800,000 population or people population criteria. We contacted the Department of Revenue, and they told us that they determined that no county qualified to use that preference after 2018. So the January 2021 legislative auditor recommendation was that the legislature modify the population criteria and extend the expiration date if it wanted the preference to be available for future use. And this session, the legislature did just that. They passed in gross substitute House Bill 1386. The bill did a number of things, most importantly, remove the population and geographic criteria so that the preference is now available, and in fact, available to any cities in the state that might meet the other. There is some other requirements that need to be met, but those limitations were removed. And in addition, the legislature extended the expiration date a few more years to give more time for this program to be used for new participants. The legislative auditor updated his recommendation to note that this preference should be continued and reviewed at a later date. And he encourages the Citizen Commission to schedule a review of this in 2028 to determine if the preference has achieved the goals of encouraging new development in underdeveloped and underutilized areas, and to increase family living wage jobs in those communities. I'll pause here for any questions.
Commissioners? Now, real quick, Dana, I did watch you present this a week, 2 weeks ago before the JLARC committee in the legislature. There was actually a fair amount of discussion. There was some, not everybody agreed with the expansion. Can you sort of give a little bit of background about the kind of the discussion that occurred there among the legislators?
Sure, we were, of course, watching this bill move through the legislature. The initial bill that was introduced did continue to have the population, or not the population limits, they increased the population amount so that it would apply to Snohomish County, but they kept the other geographic components to just be available to certain cities. As the bill moved through, there were amendments made to open it up to everyone. It kind of went back and forth, volleying around, or Grant, you like the term sausage making, but there were various amendments that both limited it and didn't limit it. The cities that had originally been targeted by this, the three in Snohomish County, said they did not have any problem with it being available to other communities. They just wanted to have it available to them. So as it ended up in what the bill that passed the legislature was a version that does not limit in any way by population or location of a county or a city who can go ahead and implement an ordinance in their city code and then offer the preference up for businesses. So yeah, it was interesting to watch. There were a lot of different changes on this. This went through a few modifications, and but this is the bill that passed by fairly large majorities in both houses.
Okay, interesting. So really, just to clarify for us, the recommendation we have to consider is this issue of just saying, basically, look, they altered this during the review process. Maybe it's better we just review at a later date. I mean, I think that's what we essentially have to decide.
Yes, hopefully by that time there will be participants and data for future staff to review and give you some good information on.
Okay. Yeah.
All right, so that concludes our presentation today. Here is all the contact information for all the staff that worked on these reviews. And if there are any other questions any of you have, we are all here. We'd be happy to answer anything that we can.
And on that, any final questions? We also do have people here online from the Department of Revenue, the Health Benefit Exchange, and people from the Liquor and Cannabis Board as well. So just see if there's any final questions from commissioners for these folks. And I am grateful these folks participated today. Okay, not seeing that.
I'm sorry, I didn't get my hand raised up here in time.
Oh, go ahead, Commissioner Viewing.
Is it possible? I would be curious to what the, on the marijuana, medical marijuana preference. There was, the legislative changes, and I would be curious if there was, any information that that would be currently available. I realize things may be in a state of flux, but anything that may be currently available from the folks on the from the the controlled substances side of things. That would be, you know, is that the ones that would be doing the regulations, or does that come from the Department of Health? It was.
Commissioner Buing, I see that Jim Morgan, the CFO of the Liquor and Cannabis Board, is attending this Zoom meeting. However, the administrative code that I referred to in my presentation is Department of Health administrative code.
Sorry.
And then the guidance to taxpayers is provided. The current guidance to taxpayers is provided through a special notice issued by the Department of Revenue.
Okay. So it's so there's in that case, then there's no reason to bother that person with questions.
Anything else? Okay. With that, again, thank you for those folks who did come and be available for their expertise. We're coming to the end here. Just a couple of things. The chair needs to remind the audience that anyone wishing to provide written testimony on the agenda topics can submit comments to, I believe there's a slide with the information on it that will be put up. There we go. Thank you. So you can see there the contact information to provide written testimony on the agenda topics. You can submit it to that email address or that email regular address in Olympia. And so you can also go to either the JLARC website or the commission website, to also the Citizens Commission's website, to get contact information. The next Citizen Commission meeting, just for public disclosure, the next meeting will take place on September 9th, 2021 at 10 a.m. And just before we go, because I don't want to forget this, now that I've meant that, I would also just put it aside, and I admit the chair has been remiss himself in looking at the new depository that staff has set up for commission documents. We asked that depository be set up so documents that we have can be sent to a single place. That is available. It was sent out in an email. So I encourage both myself and my fellow commissioners to take a look at that and make sure that functions correctly. And if you have any questions for staff, you can reach out to them. And with that, Keenan Konopasky, the legislative auditor, will explain about the public testimony process for the September 9th, 2021 meeting.
Thank you, Mr. Chair. And just as a heads up, mostly for the viewing audience, to make sure that they're aware what they should do if they wish to provide any commentary or testimony to you at the next meeting. The entire agenda is basically dedicated to public testimony on this year's reviews. So that's really the main course of business. We will, as I mentioned earlier, at that meeting, we will have the ability for members of the public to be here on Zoom and make their testimony live with you via video. There will be, so I will want folks to be aware that there will be a notice on the commission website that indicates how to register to get into the online testimony process. So for folks out there, keep an eye on the commission's website to look for that. The other thing that we wanted to make sure everybody was aware of is as the commission has done in prior years, you weighed in with some specific questions that you wanted testifying parties to address in their testimony. So we will make sure that those are posted on the website too, as a reminder for folks to hopefully take those into account when they address you at the meeting. And of course, they will anybody will still have the opportunity to provide written testimony as well, and we'll get anything provided in writing posted to the commission's website. And that was it.
Thank you. Thank you, Keenan, for that update. So with that, final questions or comments from commissioners? Okay, not seeing any. Staff, all staff, thank you very much for another successful meeting and preference review. I thought it was very interesting again, and I think the more in depth I think is a lot more useful. So I have to admit I'm enjoying that part of it. That's just the economist in me talking. So, seeing no further questions, no other comments, I call this meeting adjourned and wish everybody a good week.